Hello everyone, this is Mr. Seymour and this is Lecture 10, Chapter 9, Governing Texas. Chapter 9 covers the judicial branch, the judiciary.
A turf war between rival motorcycle gangs broke out in a restaurant parking lot. It quickly became deadly, leaving behind a gruesome scene. 9 gang members killed, the families inside terrorized. And ABC's newest correspondent, Philip Mena, is on the scene. Good morning, Philip.
George, good morning. This unspeakable act of violence that included guns, knives, and even chains all playing out in a suburban shopping center in broad daylight. This morning, investigators questioning many of the nearly 200 bikers involved in a dramatic shootout that left 9 dead and 18 injured.
I just got a call from passerby. They were going by Twin Peaks, thought they heard a gunshot, looked over and saw a lot of people running.
Authorities say the fight over a turf dispute breaking out first in the bathroom before spreading to the parking lot, involving members of 5 rival biker gangs in Waco, Texas, just feet away from families having lunch at this restaurant.
In my nearly 35 years of law enforcement experience, this is the most violent and most gruesome scene that I have dealt with.
Diners and employees locking themselves in the freezer for protection.
It was really scary. We didn't know if somebody was going to come back. They said people outside the doors had guns.
The TV show Sons of Anarchy highlighted how quickly violence can erupt between rival biker gangs.
The truth is, everything I do is to protect what we got.
For the citizens of Waco who are waking up to a citywide lockdown this morning, this shooting is all too real. Law enforcement saying this morning there are still more than 150 people detained, and given the scope of this massive shooting, it is just incredible that no innocent bystanders were hurt. George?
So lucky there. Okay, Philip, thanks very much.
The mass shootings at Waco have led to the indictments of scores of bikers. In the process, there have also been serious questions of fairness raised in the mass arrests and bail hearings of these bikers. It appears to some critics that the Texas criminal justice system has deep flaws. For example, using the shootout at Twin Peaks restaurant in Waco as an example, although it was incredibly violent, many of the bikers arrested in the incident had nothing to do with the shooting. They were taken in front of a justice of the peace, the lowest level court in Texas, who set an enormous bail to send a message, which was unusual. It was $1 million bail for each of them. Many accused were held in county jail over 2 years without reaching court, and it took more than 6 months before the first indictments began coming in. Almost everything about the case is an example of how not to handle these kinds of situations. So why did it happen in this instance? Was this a political or a judicial decision? Do you think this case was treated differently because of the amount of violence that incited it, or is this a symptom of a larger issue in the Texas judicial system?
For Marilyn and Rob Busey, life inside their Midlothian home was once full of adventure and joy.
There was never a dull moment.
Yeah.
A lot of energy, a lot of noise.
It was a home filled with 5 children, and smiles and hugs and love. Much of it focused on the newest to the family, 5-year-old Alyssa, whom Rob and Marilyn were trying to adopt from relatives in California. Alyssa came from a troubled home, and for the past year and a half, they say they have been giving her stability and raising her as their own.
We were always mommy and daddy from the start.
But all of that changed on May 17th. The day Busey hopped on his Harley and headed to a biker rally at the Twin Peaks restaurant in Waco.
When I was backing my bike out of the driveway to go to Twin Peaks, she stood in the garage and went, bye daddy, I love you.
Law enforcement all over this place.
What Busey did not realize is that he and 176 other bikers would get caught up in a fight in a deadly shootout. They would be arrested and spend the next month behind bars. There was no way to know it would be the last time he would see the little girl who called him daddy.
It really breaks my heart. I mean, she was daddy's girl. Big time.
While Busey was in jail on $1 million bail, charged with murder and organized crime, he received a notice of emergency removal from California officials who halted the adoption. They called Busey a threat and ordered Alyssa removed from the home. Busey says while he is a member of the Cossacks who were involved in the fight, he played no role in it. The Buseys say, despite the endorsement of their Texas caseworker, Marilyn was ordered to pack Alyssa's bags and toys and stuffed animals and deliver her to a stranger at the airport.
Trying to get her excited about going on a vacation, because I didn't know what else to. What do you say? And it was so hard because he wasn't here. It was, just me and.
Alyssa is now with a foster family in California. The Buseys don't know where. They're not allowed to speak to her and have filed an appeal.
I feel that I've done everything that I can do to show the court, show the judge that, we love her. This is our daughter. She's here with family. She needs to come home.
For now, all the Buseys can do is hope this message somehow gets to the little girl whom they love, the one who still calls them Mommy and Daddy.
I'm so proud of you. I know you're being such a brave big girl, and I miss you. I miss you, and I love you, and I'll see you as soon as I can. As soon as I can.
Now, the courts are responsible for securing liberty and equality under the law. And in Texas, all judges are elected. This puts voters and interest groups into direct involvement in the judicial selection process. Texas's large and complex court structure consists of courts with overlapping jurisdiction and courts with specialized jurisdiction that we'll see here in a few moments. This is the court structure. We start with a Supreme Court and a Court of Criminal Appeals at the top. They're equal. So we have not one but two high courts. Then the Court of Appeals, then the district courts, then the county level courts, and the municipal courts and the Justice of the Peace courts. The structure of the Texas judicial branch is laid out in Article 5 of the Texas Constitution and is further defined by statute, in particular the Texas Government Code and the Texas Probate Code. The structure is exceedingly complex, featuring many layers of courts, numerous instances of overlapping jurisdiction, both in terms of amount and controversy on questions of specific territorial authority, a myriad of differences between counties, and an unusual bifurcated appellate system at the top level found in only one other state, Oklahoma. The municipal and Justice of the Peace courts are the most active courts, with the county level and district courts handling most other cases and often sharing the same courthouse. Administration is the responsibility of the Texas Supreme Court, which is aided by the Texas Office of Court Administration, the Texas Judicial Council, and the State Bar of Texas, which it oversees. The State Bar of Texas is a mandatory bar rather than merely an association of lawyers such as the ABA or local bar associations. This means it plays a formal role in Texas government rather than just as an advocate or special interest for the legal profession. In order to practice law in Texas courts, an attorney must be licensed and must pay dues. The public can obtain basic information on all Texas attorneys, including their bar number, license status, and disciplinary record, from the bar's website at texasbar.com. In the 19th century, Texas had a reputation for arbitrary frontier justice, as exemplified by the Justice of the Peace Court of Judge Roy Bean, who fancied himself as the law west of the Pecos. The poor quality of the state's judicial system in Texas over the early period has been attributed to its then shortage of proper law schools and law libraries, as well as the traditional preference of Texans for self-help justice. Texas is the only state besides Oklahoma to have a bifurcated appellate system at the highest level. This means Texas has not one but two high courts. The Texas Supreme Court hears appeals involving civil matters, and the Texas Court of Criminal Appeals hears appeals involving criminal matters. One notable exception is in the case of juvenile justice cases, which are considered civil in nature and heard by the Texas Supreme Court rather than the Court of Criminal Appeals. Unlike its counterpart in Oklahoma, the Texas Supreme Court is not really supreme when it comes to a jurisdictional game of ping pong or tug of war between the two high courts, because both are co-equal. Article 5, Section 1 of the Texas Constitution states, "The judicial power of this state shall be vested in one Supreme Court, in one Court of Criminal Appeals, in courts of appeals, in district courts and county courts, in commissioners' courts, in courts of justices of the peace, and in such other courts as may be provided by law. The legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district and other inferior courts thereto." As such, the Texas legislature has created additional courts to address caseload pressures driven by population growth in different areas of the state. Further sections of Article 5 spell out the basic requirements for each court's jurisdiction and for its officers. The Texas Supreme Court hears appeals involving civil matters and does not hear any appeals involving criminal matters except when the defendant is a juvenile. Under Texas law, juvenile proceedings, even those involving criminal activity, are considered civil matters under the Texas Family Code. Thus, the Texas Supreme Court hears such appeals, but it defers to the Texas Court of Criminal Appeals in matters where the Texas Penal Code must be interpreted. The Supreme Court also maintains responsibility for attorney licensing and discipline. The Texas Court of Criminal Appeals hears appeals on criminal cases, excluding those involving juvenile proceedings. Cases in which the death penalty was imposed are directly and automatically appealed to this court, bypassing the intermediate courts of appeals, which hear both civil and criminal cases. Texas has 14 courts of appeals which have intermediate appellate jurisdiction in both civil and criminal cases. Death penalty cases, however, are automatically appealed to the Texas Court of Criminal Appeals and thus skip the intermediate tier in the appellate court hierarchy. The total number of intermediate appellate seats is 80, with membership ranging from 3 to 13 justices per court as set by statute. All cases are heard by a 3-justice panel unless a hearing en banc, meaning all justices at once, is ordered, except where a particular court has only 3 justices assigned to it, in which instance all cases are automatically heard en banc. An example is the 12th Court of Appeals. The en banc process is used to maintain consistency in the court's jurisprudence, to overrule existing precedent that is binding on individual panels, and to set new precedent on an unsettled question of substantive law or procedure. The Texas legislature determines which counties are included within a particular Court of Appeals' district, and has shifted counties between courts to balance the docket. The Texas Supreme Court seeks to even out imbalances in appellate caseloads on an ongoing basis with docket equalization orders that provide for transfers of batches of cases from the busiest appellate courts to others with spare capacity. In an oddity, 2 of the 14 courts, the 1st and 14th, both sitting at the repurposed historic 1910 Harris County Courthouse in Houston, have concurrent jurisdiction over the same 10 counties, the largest being Harris County. Parties who want to appeal a case from a court in any of these counties are required to state in their notice of appeal that they wish to appeal to either the 1st or the 14th Court of Appeals, and then must wait and see to which one of the 2 they are assigned randomly. An even more bizarre situation occurs in East and North Texas, where the 6th Court has 4 counties, Gregg, Rusk, Upshur, and Wood, which overlap with the 12th Court, and also has Hunt County overlapping with the 5th Court. The Texas District Courts are the trial courts of general jurisdiction. The District Court has exclusive jurisdiction on felony cases, cases involving title to land, and election contest cases. It shares jurisdiction with the county courts, and in some cases, justice of the peace courts, for civil cases. Its lowest limit for hearing a case is a mere $200 in controversy, while JP courts can hear cases up to $10,000. Family law jurisdiction varies depending on the existence of a county court at law. In some counties, the district courts share jurisdiction over divorces, child custody, and support matters, adoptions, and child welfare cases with the county courts at law. Also, probate jurisdiction dealing with the adult protection, guardianship, and execution of wills varies depending on the existence of a statutory probate court in the county. In some larger counties, such as Harris County, the district courts are specialized, some hearing family matters, others hearing criminal cases, and a third set hearing non-family civil cases. In more rural areas, as many as 5 counties share a district court. Urban counties, on the other hand, have multiple district courts which in some cases specialize in civil, criminal, family law, or juvenile matters. One of the most unusual features of Texas trial courts, including district courts, is the tradition of having only 1 judge per trial court. Instead of adding more departments to existing courts in response to population growth, Texas adds more courts. The result is that a typical Texas urban courthouse is home to many single-judge trial courts, each of which is legally organized as a separate court with its own unique name and number. This contrasts sharply with the prevailing tradition in the federal judiciary and the courts of virtually all U.S. states, in which a trial court can have multiple judges sitting in separate departments, and all of which have authority to act in the name of the same trial court. While Texas law provides for certain specific circumstances in which a judge of one trial court can act for an absent judge of another trial court in the same jurisdiction, it is not as flexible as simply treating all trial judges as members of the same court, and in turn occasionally results in another basis for appeal. This tradition dates back to the hurried enactment of the Constitution of the Republic of Texas in 1836 by the newborn republic. Section 2 of Article 4 provides for not less than 3, no more than 8 judicial districts, and that a judge would be appointed for each district. Similar clauses implying one judge per court appeared in all subsequent constitutions. For example, Section 7 of Article 5 of the 1876 State Constitution provides for 26 judicial districts, and that a judge would be elected for each district. The issue was finally remedied by a constitutional amendment in 1985, but the tradition of one judge per trial court was by then thoroughly entrenched. Some counties, however, have established a centralized docket system. In that system, cases are still assigned to a particular court and a particular judge presiding over that court, but motions and trials are assigned to judges on the day of the docket call based on workload considerations and availability. This facilitates more effective use of judicial resources, both judges and staff, but it makes the process less predictable for attorneys. Additionally, rulings in the same case are likely to be made by different judges as the case progresses through the pretrial stages, and hearing judges will be less familiar with the cases that they encounter for the first time at the time of the hearing. In counties that do use this type of system, attorneys know which judge will hear their motion and try the case, except when a visiting judge is assigned to sit for an absent presiding judge, which allows experienced attorneys and law firms to assess likely case outcomes and thus facilitate settlement. In complex cases with multiple hearings, the judge will become familiar with the case and the attorneys litigating it. On the other hand, a local court system in which the case stays with the same judge creates incentives for forum shopping. To counteract it, local rules typically require random assignment of cases when they are first filed and transfer of refiled cases after non-suit to the court to which the prior case was randomly assigned. The same applies to severance and other related cases. In another unique twist, the Constitution grants the legislature the authority to determine which court handles probate matters. Thus, in 10 of the 15 largest counties, specifically the counties of Bexar, Collin, Dallas, Denton, El Paso, Galveston, Harris, Hidalgo, Tarrant, and Travis, the legislature has established one or more statutory probate courts. These specialized courts handle matters of wills and probate, guardianship, trust, and mental health. In some counties, the statutory probate courts also hear condemnation cases. There are no judicial monetary limits on the amounts of lawsuits that a statutory probate court may hear. As such, their jurisdiction at times overlaps that of the district court. Not to be confused with county courts at law, which are created by statute, there is a county court for each of the 254 counties in Texas. The Texas Constitution states that there shall be established in each county of the state a county court. Section 15 through 17 of Article 5, as well as chapters 25 and 26 of the Texas Government Code, outline the duties of these courts and their officers. The county court has exclusive jurisdiction over Class A and Class B misdemeanors. Those offenses can involve jail time. Concurrent jurisdiction over civil cases where the amount of controversy is moderately sized, and appellate jurisdiction over JP and municipal court cases. For municipal court cases, this may involve a trial de novo, if the lower court is not a court of record. County court judges are not required to be licensed attorneys. Due to this, defendants in counties which only have the traditional constitutional county court may ask to have their cases transferred to that county's district court for trial if the district judge consents. However, defendants in counties with the county court at law structure do not have this option, as the county court at law judges are required to have law degrees. Since the county judge is also responsible for presiding over the Commissioner's Court, the main executive and legislative body of the county, in 94 counties, the Texas legislature has established county courts at law to relieve the county judge of judicial duties. In most counties with courts at law, the civil and criminal jurisdiction of the constitutional county court has been transferred to the county courts at law, leaving only administrative duties, Commissioner's Court. Unlike the county judge, judges of the county courts of law are required to be attorneys. The county courts at law may hear both civil and criminal matters or hear them separately, depending on how the legislature has structured them. Dallas, Denton, El Paso, Harris, and Tarrant counties have county criminal courts or county criminal courts at law that hear only criminal cases. Statutory county courts at law, not to be confused with constitutional county courts, generally have broader jurisdiction than constitutional county courts. Statutory county courts can generally entertain lawsuits in which the amount of controversy is over $500 but not over $200,000. However, unlike constitutional county courts, the jurisdiction of statutory county courts can vary from county to county. For example, in Dallas County, statutory county courts have jurisdiction near as broad as that of district courts. In Harris County, the general jurisdictional cap is $200,000, but these courts also have exclusive jurisdiction of eminent domain proceedings regardless of the amount in controversy. In Travis County, the amount in controversy for matters the statutory court can entertain ranges from $500 to $250,000. There is no clear policy reason for the varying jurisdictions of the statutory county courts. Municipal courts in Texas come into contact with more defendants than all the other Texas courts combined. The subject matter of municipal courts relates to crimes relating to public safety and quality of life issues. In recent years, municipal courts and justice court in Texas have become the primary venue for acts of misconduct committed by children. Within the city limits, these courts have shared jurisdiction with the JP courts on Class C misdemeanor cases and have exclusive jurisdiction on cases involving city ordinances. Municipal courts have limited civil jurisdiction over public matters relating to public safety, for example, dangerous dog determinations and city quality of life ordinance issues. Confusion surrounding a municipal court civil jurisdiction is complicated that if a municipal court is a court of record, the legislature has authorized municipalities to adopt ordinances that give municipal courts concurrent jurisdiction over substandard building cases with county and or district courts. The matter of civil jurisdiction has been further confused by the advent of civil penalties for conduct that can be prosecuted as a Class C misdemeanor. For instance, certain parking violations and red light camera violations. As a general rule, the municipal courts are not courts of record, meaning no court reporter records or transcribes the proceedings, and thus an appeal to the county level would require a whole new trial, also called a trial de novo. This proved to be a loophole for some defendants in traffic cases who bet on the officer not being able to attend, and thus having the case dismissed. Furthermore, the de novo trials crowded the dockets of the already busy county courts at law. Many major cities, such as those in Austin, El Paso, Houston, Dallas, and San Antonio, have chosen to convert their municipal courts to courts of record. This also requires voter approval to close this loophole. Municipal court cases generally have their appeals heard at the county court level, but cannot be appealed beyond that level unless the fine is more than $100 or a constitutional matter is asserted. The lowest court level in Texas is the Justice of the Peace Court, also called Justice Court or JP Court. Each county has at least one JP Court. Article 5, Section 19 of the Texas Constitution sets forth the minimum jurisdiction of the JP Court. Original jurisdiction in criminal matters of misdemeanor cases punishable by fine only, called Class C misdemeanor cases under the Texas Penal Code. Exclusive jurisdiction in civil matters where the amount of controversy is $200 or less, and such other jurisdiction as may be provided by law. Under this provision, the legislature has raised the top limit on civil matters to $10,000 and assigned the JP courts, among others, the right to hear cases involving eviction as well as cases involving foreclosure and liens against personal property, where the amount falls within the JP court's jurisdiction. In addition, marriage licenses are obtained through JP offices, and JPs are also legally permitted to perform marriage ceremonies. JP cases are appealed to the county court level, where the case results in a trial de novo. While the case is retried on appeal, the jurisdictional limits of the JP court, rather than those of the court of record, usually a county court at law, apply. Appeals from JP Court also differ from appeals to the Courts of Appeals in that they require This makes such appeals more onerous to losing defendants than appeals from county courts to the Court of Appeals, unless the defendant qualifies to proceed in forma pauperis, without financial resources. In criminal cases, cases beginning in justice court cannot be appealed beyond the county court unless the fine is more than $100 or a constitutional matter is asserted. Under Section 18, the number of JPs and associated constables, each county has as many constables as JPs, is dependent on the size of the county. Constables are elected officials who serve 4-year terms. A constable in Texas serves as a licensed peace officer and performs various law enforcement functions, including issuing traffic citations, serving warrants and civil papers such as subpoenas and temporary restraining orders on behalf of the Justice of the Peace Court to which they are elected. The Texas Supreme Court is the highest civil court in the state. It has 9 justices. They're all elected. They hear civil and juvenile cases only. They have final appellate jurisdiction in the state. The minimum requirements for being a Texas Supreme Court justice are that you must be a U.S. citizen and resident of Texas, be at least 35 years of age, and have been either a practicing lawyer or judge for at least 10 years. There's a 6-year term, at least 3 justices are elected every 2 years, and the salary is $168,000 per year.
Texas has 2 high courts, the Texas Court of Criminal Appeals and the Supreme Court. This is Camille with the League of Women Voters of Texas. The Supreme Court sees civil and juvenile cases. Civil cases are between people or institutions like businesses, typically over money. Civil cases include fraud and property rights. The court includes Chief Justice and 8 judges. These judges choose which cases they want to review, determine whether or not to overturn lower court rulings, and have control over the State Bar Association, which oversees all lawyers in the state. The American Bar Association advises voters to consider a few things when deciding who to vote for. First, do the candidates have a history of upholding the law? Are they independent and impartial? Do they have a good temperament and character? And are they qualified for the job? These are all important questions to answer before voting. Make sure your voice is heard in the primaries and general elections, and find out more information about the candidates at lwvtexas.org.
Vote!
The justices, there are 9 justices in the Supreme Court. This was the justices in 2014. The Texas Court of Criminal Appeals is the highest criminal court in the state. It has 9 justices or judges with the same pay, terms, and qualifications as the Texas State Supreme Court. It is the final state appellate authority over criminal cases. It has jurisdiction over automatic appeals in death penalty cases. Usually, initial appeals are heard by one of the 14 other courts of appeals in Texas. The 80 judges for the courts of appeal are required to have the same qualifications as those of the higher courts. They are paid $168,000 per year.
Texas has 2 high courts, the Court of Criminal Appeals and the Supreme Court. This is Camille with the League of Women Voters of Texas. The Texas Court of Criminal Appeals is the highest court for criminal cases. The court includes a presiding justice and 8 judges. Judges decide what criminal cases they want to hear. They are responsible for sentencing in death penalty cases and cases involving constitutional rights. The court is in charge of public funds to educate judges, prosecutors, and defense attorneys who represent defendants who cannot afford a lawyer. The court also rules over judicial eligibility and vacancies on the court. The American Bar Association advises voters to consider a few things when deciding who to vote for. Do candidates have a history of upholding the law? Are they independent and impartial? Do they have good temperament and character? And are they qualified for the job? These are all important questions to answer before voting. Make sure your voice is heard in the primaries and general election. You can find more information about the candidates at lwvtexas.org.
Vote.
The major trial courts in Texas are the district courts. These are the workhorses. They have general jurisdiction. District courts usually have general jurisdiction. However, in urban counties, some district courts with specialized jurisdiction hear only civil, criminal, juvenile, or family law matters, while those with general jurisdiction hear felony criminal cases, divorces, land disputes, election contests, and civil lawsuits.
Texas district courts are the workhorses of the court system. They handle felony criminal offenses and many civil issues. Keep in mind, in this screencast we're talking about Texas district courts, not federal district courts. Texas district courts are created by the legislature and are granted criminal jurisdiction by the Code of Criminal Procedure. District courts have original jurisdiction of criminal cases which are felonies. They also have jurisdiction of misdemeanors which involve official misconduct. For instance, the charge of official oppression, such as when a peace officer is alleged to have used his or her authority to commit a crime. Official oppression, again, just one example, is heard in a district court even though it's a Class A misdemeanor. A district court can also hear a case which is a misdemeanor which is transferred from a constitutional county court under certain circumstances. This would be very rare though. District courts also hear a multitude of civil matters. These include divorce cases. You are married by a justice of the peace in Texas, but divorced by a district court judge. District courts also hear child custody and child support cases. Another example of a civil matter which closely affects criminal law is the consideration and adjudication of protective orders in family violence cases. Keep in mind a protective order, as we'll learn about in Unit 6, is a civil order that is criminally enforceable. These are just some examples of the civil case law matter that can be heard in the district courts.
Each county has a county judge. The county judge presides over the county's commissioner's court and has responsibilities for county government, but they also preside over the county court. The county courts have jurisdiction in some probate cases and serious misdemeanor criminal cases.
County-level courts were very important to Texans in the 19th century. They have been considered fundamental to local governance and, like justice courts, were important enough to be mentioned in the Texas Constitution of 1876. We'll discuss the 2 main types of county-level courts in this screencast. The Texas Constitution provides for one county-level court per county. Because of this, the first type of county court we'll discuss is called a constitutional county court. Again, it's created by the Constitution. Now, while this court can serve as a criminal court, in most cases, it serves as the organization which runs the county in regards to things like roads, bridges, elections, budget, and infrastructure. Constitutional county courts are granted criminal jurisdiction by the Code of Criminal Procedure, but in most cases, the criminal docket is probably handled by the second kind of county court we'll discuss, a county court at law. In all counties in Texas, the constitutional county court judge will meet with the county commissioners and see to finances and the well-being of the county. In this capacity, where the county judge acts as the chief executive officer of the county, the constitutional county court could be referred to as the commissioner's court. If there is not a county court at law in the county, in other words, the constitutional county court is the only county level court in that county, the constitutional county court can also hold a criminal docket. In this capacity, where the county judge presides without the commissioners and hears criminal cases, the constitutional county court has original jurisdiction over Class A and Class B misdemeanors that occur within the county. If the constitutional county court does have a criminal docket, then it will also hear appeals from justice courts and municipal courts. Finally, just like justice and municipal courts, the county judge does not need to be an attorney to hear criminal cases. So, remember, every county in Texas has a constitutional county court. A county may also have one or more statutory county courts. This is the second type of county level court we'll discuss. These types of courts are known as county courts at law. In populous counties, they are usually numbered, such as County Court at Law number 1 or number 2. In rural counties with only one statutory county court, it may simply be called the County Court at Law. They are called statutory because they are created by the legislature, as opposed to justice and constitutional county courts, which are created by the Texas Constitution. So, if a county has one or more county courts at law, then it will take over all of the criminal and civil law responsibilities from the constitutional county court. If this is the case, the constitutional county court will only run the county and commissioner's court. This means the county courts at law will hear the criminal docket for Class A and Class B misdemeanors which occur in the county, and they'll also hear appeals from justice and municipal courts.
Larger counties in Texas have statutory county courts at law. These tend to hear less serious cases and jurisdiction varies significantly between counties. In the most urban areas, courts known as statutory probate courts have been created. Specialized courts whose jurisdiction is limited to probate matters relating to the disposition of property of deceased persons and guardianship matters. All counties in Texas have between 1 and 8 justices of the peace. Local trial courts with limited jurisdiction over small claims and minor criminal misdemeanors.
Justice of the peace courts are regarded as the courts closest to the people, and that you don't need to hire a lawyer to defend yourself against criminal charges or to file a lawsuit. In this screencast, we'll talk about the characteristics of the justice courts pertaining to both criminal and civil matters. While the Texas Constitution establishes justice courts, the Code of Criminal Procedure grants them their criminal jurisdiction. Justice of the peace courts in Texas cover areas outside of incorporated cities, but within the precinct. These are sometimes referred to as unincorporated areas of the county, and a justice of the peace does not have to be an attorney. This means if you wanted to, after you finish your law enforcement, corrections, or law career, you could use your experience to run for election as a justice of the peace. Justice courts have original jurisdiction of criminal cases punishable by fine only. In other words, Class C misdemeanors. Justice courts also have jurisdiction over certain offenses in the Alcoholic Beverage Code, which are fine only. Justice of the peace courts also serve as a small claims court. Let's say you hire a plumber to come to your house to fix a leaky faucet, but instead he makes a mistake and causes $2,000 in damage and refuses to pay for it. Your legal course of action is to file a small claims lawsuit against him in the Justice of the Peace Courts. Now, under ordinary circumstances, if you're suing for $2,000, you could quite easily exceed $2,000 in hiring an attorney and paying court costs. Filing the claim wouldn't be worth it, and the plumber would not be held accountable for the damage he did. In a justice court, though, you need not be represented by an attorney, and you can file and pursue the lawsuit yourself and avoid the cost of hiring an attorney. This benefits the public by keeping the threat of monetary damages real. Private individuals or businesses have an incentive not to cheat others in non-criminal ways with the presence of the small claims function in the justice courts. Justice courts can hear small claims up to $10,000, so you can sue by yourself and without hiring an attorney to represent you for up to that amount. Since there are often more than one justice of the peace precincts within the same county, the Code of Criminal Procedure addresses how those precincts and justices will work together handling criminal defendants. According to the Code of Criminal Procedure, a defendant must be tried in the precinct where the offense was committed, or in the precinct in which the defendant resides, or in any other precinct in the county with the defendant's consent. If, in a county of a population of 3.3 million or more, the defendant may be tried in the adjacent precinct where the offense was committed, or if there is no JP in the precinct where the offense was committed, for instance, the JP dies or is removed from office and a new one has not been appointed or elected, a defendant must be tried in the next adjacent precinct or the precinct where the defendant resides. Finally, the Code of Criminal Procedure also specifies a justice of the peace shall have the power to take forfeiture of bonds, that is, to collect money when a bond is revoked.
In each of the incorporated cities of Texas, the legislature has created municipal courts. These have jurisdiction over violations of city ordinances. Municipal judges may issue search and arrest warrants, but they have only limited civil jurisdiction. They function primarily as traffic courts.
Municipal courts are cousins to Justice of the Peace Courts, but there are some significant differences. We'll talk about the similarities and differences in this screencast. Just like justice courts, municipal courts are granted criminal jurisdiction by the Code of Criminal Procedure. Remember, Justice of the Peace Courts cover unincorporated areas. Municipal courts, on the other hand, cover the area within an incorporated city or town. That means the village, town, or city has a mayor and or a city council, its own fire department or police department, or they contract for services from other agencies for public safety. A municipal court has original and exclusive jurisdiction for all offenses within the city that are against city ordinances. City ordinances are laws that a city passes that only apply to a person while they are within the city limits. An example might be a leash log for your dog, a law banning fireworks in city parks, or a law prohibiting you from having saggy pants. These types of laws aren't found in any of the Texas code books, are only enforceable within the city's limits, and typically would be passed by the city council. There are three types of ordinances a municipal court has jurisdiction over. The first kind would involve a fine no greater than $2,000 for violations of fire safety, zoning, which are ordinances which prohibit building something like a strip club right next to a daycare center, or public health and sanitation. The second type of ordinance would involve an offense which may be punished by a fine no greater than $4,000 for violations of the dumping of refuse. The third type of ordinance that a municipal court would have original and exclusive jurisdiction over would be any other ordinance which involves a fine no greater than $500. This would be an ordinance such as no loud music in a residential area, or an ordinance banning large signs posted in front yards. Again, these ordinances are fine only. A city council doesn't have the power to make a law that is anything other than a fine. Speaking of fine only, we've touched on this in a previous screencast. Justice of the Peace Courts have original jurisdiction of criminal cases punishable by fine only. In other words, C misdemeanors, which are found in Texas codes such as the Penal Code and the Alcoholic Beverage Code. In most cases, the Justice Court will gladly allow the municipal court to handle these offenses which occur within the city limits to reduce their workload. The Code of Criminal Procedure addresses one more situation which might make for complicated enforcement. A situation when two cities are located right next to each other. For example, let's say these two shapes represent the jurisdictions of two cities on a map, and you are a peace officer in the purple city, which has an ordinance preventing loud noise in a residential area. A citizen calls you and says, "Look, I live in a residential area in the purple city, and my neighbor who lives across the street in the light blue city is making a loud noise." If the light blue city doesn't have a noise ordinance, you have to tell the citizen there's nothing you can do. Laws are made to protect and also enforce social norms. In the case we've just described, a city ordinance designed to maintain peace and quiet is pretty worthless for the citizen who lives on the border. The Code of Criminal Procedure recognizes this and allows for a buffer zone of sorts if one of the two cities has more than 1.19 million people. If this is the case, then the ordinance of one city may overlap into the other city, so you don't have to tell the citizen he's out of luck. Instead, you call your friend who's on duty as a peace officer in the light blue city and ask him or her to go write the loud neighbor a ticket for the noise ordinance which exists in the purple city. In other words, the cities have concurrent jurisdiction over the ordinance if they agree. The Code of Criminal Procedure sets it at 200 yards from the city border for C misdemeanors or by a half a mile for certain offenses under the Health and Safety Code.